Well, the big story in Washington this week was obviously the immunity case for Donald Trump heard by the Supreme Court. It could have reverberations on future presidencies and, of course, the criminal cases against the former president that prosecutors certainly hope will get done before the election in November. Joining me to talk about the arguments heard by the High Court on Thursday, Dr. Mark Caleb Smith. He's a constitutional law expert and director of the Center for Political Studies at Cedarville University. Dr. Smith, thank you so much for joining me here on the DC Debrief.
Happy to be with you. It's my pleasure.
It's great to talk to you. And, a lot of times I think you get a sense for how the justices are leaning about a certain case that comes in front of them by the questions that they're asked. And so where they're coming from with the questions oftentimes gives you a sense, do they believe in this case? Do they not believe in this case? Are they skeptical, not skeptical? Based on what you heard on Thursday, the questions posed by the majority of the justices, do you get a sense that they are leaning one way or the other?
It certainly feels like they're skeptical of a broad immunity claim. And so they don't seem that interested in finding that the president would be free from any kind of criminal prosecution, regardless of his actions. Even the more so-called conservative justices were raising hypotheticals about SEAL Team 6 assassinating political opponents and things along those lines. And so I think there's a lot of skepticism about blanket immunity. I also think there's a little bit of skepticism about no immunity whatsoever. And so there seemed to be, if I had to read it, I think there's a little bit of a middle ground that's probably emerging where almost all of them thought maybe some actions should be protected for the president, but certainly not everything and certainly not from all criminal law.
Well, to your point then, a couple of the justices, I believe it was Kavanaugh and Alito, seem to indicate that because there might be some instances where the president should have some immunity protection, that perhaps this should be taken down to a lower court. A lower court should hear more arguments on this. What would be the purpose of that? What's the reasoning for sending this down to a lower court?
So this is all, of course, this is in the context of a trial. And even though the university, or even though the Supreme Court's dealing with this legal question, it's also in the context of whether or not this trial with President Trump can move forward or not. And so the lower court hasn't necessarily fully looked into, for example, the difference between a public act or a private act. If we're going to say maybe the president enjoys immunity for public behavior but not private behavior. Well, if that's the rule the court puts in place, then that would require a lower court to look at this particular instance and say, okay, based on these actions, here's a reasonable definition of which of these things were public, which of them were private, and therefore the prosecution could proceed after that. But of course, even that could be appealed. And so they're going to push this down maybe to a lower court to further clarify some of those questions. And then it's possible they would have to hear this all over again based on that argument they get from a lower court.
Now, a lot of this, why this case is being heard now, is the timing. It plays a big role in what the justices decide, because, like I mentioned, prosecutors want to get these cases going now, as soon as possible, because they want to have a verdict one way or the other before the November elections. And they obviously feel their cases are strong. They feel they can get a conviction of some kind against the former president. So if this does get dragged out and lower courts get involved in this case, has to come back to the Supreme Court at some point, it seems almost impossible that if these cases are going to take 3 months, that it could be decided by the time the general election, by the time election day rolls around. Is that a fair reading?
I think that's more than fair. If this gets pushed down to a lower court for more decisions, then you're looking at a long delay, potentially a year or plus of a delay while arguments float back and forth. It's also possible, and you heard Justice Barrett raise this as a possibility in one of her questions, if the parties kind of agree on which actions were private and which ones were public, maybe the case could go forward looking at those private actions alone while the public questions get adjudicated outside of that setting. And so it's possible the court could enter the kind of order that would say, we think you can move forward. You have enough information to move forward. We have a clear principle that would allow for a lot of this prosecution to occur. Even though some of these issues might be kicked up in a different direction, we still think the prosecution could go forward. And so it's possible that this could actually happen relatively quickly. The court could return a verdict, and then we'd see the trial sort of resume, if we want to think of it like that. Also possible the court kicks this back down, we get more hearings, and we end up with a long delay. But I think you're right. Looking at the sense of it right now, I'd be shocked if this unfolds quickly enough for it to be done before the election, almost no matter how it shakes out.
at its heart, what is the Trump legal team's argument for full immunity, and how does it affect some of the cases, some of the trials that he's facing here this summer and fall?
The Trump team's argument is essentially for a blanket immunity for the president's public actions. In other words, if he's performing an action in the context of being president of the United States, relying on power that's given to him by the Constitution or given to him by statute, he should be free from criminal prosecution. However, they do admit if the president is impeached and removed for something, then he could be prosecuted for what he is impeached and removed for. And they see that as really the only scenario where the president could be prosecuted like that. If obviously the court were to grant that, that would obliterate most of these cases that are standing against the president at the federal level. It would not affect the cases at the state level, but it would at the federal level.
So the Georgia case and, of course, the New York case, which is ongoing
Correct.
right now, would remain in place. But we're talking about the 2020 election interference case against him and the classified documents at Mar-a-Lago case against him. Both of those cases would be imperiled if the court were to side with the Trump team.
That's correct. Yeah, I think that's correct. I think it's highly unlikely they do side with them that strongly, but yeah, that's the outcome.
At one point, Sawyer was asked, the Trump lawyer, sorry, I'm forgetting his first name, John Sawyer's name. John Sawyer was asked by a couple of the justices about, I think it was Sonia Sotomayor asking about an assassination. You know, like what if the president saw a potential political rival as a threat and in his role as president ordered an assassination on that particular person? Could that be deemed a public act that he would be immune to? And it seemed as though the Trump lawyer agreed that yes, it could potentially be something he was immune to. Were there any? It seemed to me that was the most explosive interface between the two sides during the hearings.
Yeah, I would say that's probably true. There's the other question about a coup. If the president ordered a coup attempt, similar response, depending on the context, he said those could be considered public acts and that would be immune from prosecution. It really seemed like very few justices were willing to to go down that road because of how radical of a statement that really is. Now, in the Trump team's defense, their argument is if we open up the door for criminal prosecutions, then we're really just going to look like a banana republic. Once Trump leaves office, the Biden administration prosecutes him. Once he leaves office, whoever comes in after Biden prosecutes him. And they're worried about sort of this infinite cycle of just retribution against whoever holds the office. You can see historically and contemporarily how that does happen in some countries. And so I can understand their desire to avoid that, but to claim that somehow the president would be beyond the law, even for what we would all say is a criminal act, seems like an awful lot to ask for.
So at the end of the day, do you have a guess or do you have a sense as to when the Supreme Court may decide on this case? Does it seem to you that they're looking to make a decision on this sooner rather than later? Because they waited a little while before hearing the case. I mean, they didn't rush this to the docket as soon as the Trump legal team asked the Supreme Court to take a look at it.
Yeah, so far we've got no sense that they look at this as kind of an expedited case that they're going to handle quickly and turn around. They don't feel bound by the timeline of the campaign. You know, the prosecutors in this case do. President Trump is certainly trying to push and delay this past the campaign as much as possible. The Supreme Court, in a way, doesn't care. And I think that's honestly to their credit because they're not treating him any differently than they would anyone else. We don't see this as a timely issue. We're just going to render our verdict when we want to. If that's the case, we probably wouldn't see a decision on this until the end of June because this is a late argument. I think this is the last day of arguments at the court. They sometimes hand down decisions mid to late June. That would give them still a couple of months before they do this. And of course, depending on the nature of the agreement, how extensive the opinion is, you're talking about a long process of writing, editing, circulating briefs. That takes a good bit of time as well.
Well, it's a fascinating situation, and it's one of the more important cases the Supreme Court has heard in the last few years. Certainly has, like I mentioned at the top of our interview, ramifications for future presidencies and, of course, for these court cases and the November election. So certainly we're keeping a close eye on this, and we'd love to have you back sometime in the future when a verdict is rendered and get your thoughts on what that might mean moving forward. Dr. Mark Caleb Smith from Cedarville University, thank you so much for joining me here on the DC Debrief. I really appreciate it.
My pleasure to be with you, and I'd love to get back with you in the future. Take care.